Good evening, everybody. Welcome to Zoom at 8. My name is Julianne Peterson, and I am your host every Tuesday night here at Zoom at 8. I am a loan officer, senior director at Old Capital Lending, and we are a premier provider of debt and creative solutions. So, what does that mean to you or to your friends? I would encourage you to let us be your lender of choice. Let us have that opportunity. We're going to need your T12, your rent roll, the OM, and your underwriting. And we will give you exactly based on those financials where they are today. Now, if that seller takes their foot off the gas, that is a problem. So you want to make sure your LOI has the right information in it to support what's going to happen on the debt. So lots of crazy stuff. I want to welcome all of the new people here, as well as those returning Zoomers. So, we've been doing this for over 4.5 years. We are on our 5th year. So we are here 3 weeks out of the month with industry experts. And tonight we have Gene Trowbridge. He is a legend, and you're going to learn a lot tonight. And hopefully, if you have to run out, make sure you take with you the chat. Everybody needs to start loading their information into the chat. This is like going to a conference where you don't even have to get on a plane, train, or an automobile to get here. You just need to show up at your desk and have an hour and a half of investing in yourself. So let us learn about Gene Trowbridge. Again, if you are new to Zoom at 8, we have industry experts 3 nights out of the month, and then we just network the rest of the time. If everybody would put themselves on mute, that would be awesome. I got you, Adriana. All right. So Gene Trowbridge is here tonight. He has been in the commercial and investment real estate business continuously since 1972, and a legal professional since 1996. There are people in this house, in the room, that are younger than 1972. So you don't know, you might not know Gene, but he has been around for a long time and has the awards to prove it. He was awarded the CCIM designation in 1977, which is a very long time. He knows his stuff. Gene is a member of the California Bar and founding member of Trowbridge Nieh Law Group, concentrating on the syndication of commercial and investment real estate. As a former syndicator who for 10 years raised investor capital, served as a sponsor of 16 investment groups, raised equity from investors, Gene sent out nearly 1,700 K1s that year. Can you believe that? That is a ton. The firm has written over $5 billion in monies raised. So the practice rates offerings under the Rule 506B and 506C of Regulation D. He also does Regulation CF and Regulation A+. His articles have been published in various real estate media outlets, and Gene authored his first book, It's a Whole New Business, in 2005, and the 4th edition was released 2 years ago and is available on Amazon. Gene married Kay, his wife, 51 years ago. Oh my gosh. They have 2 daughters, and Gene has run 37 half marathons since he was 60 years old. Take that, Mr. Where's Dinesh? I think Dinesh is a runner too. Listen, I am excited to introduce you all to Gene Trowbridge. He is amazing, and welcome, Gene, to Zoom at 8. How are you tonight?
Well, thank you, Julianne. That was great, and I appreciate everyone being here tonight. That's wonderful. And before I talk about what I'm going to talk about, I just want to tell you about the homework calls I get quite often, because it really fits in with what I've heard here. I'll get a call from someone who says, I've been a passive in 20 deals, and Gene, I want to be the lead. I want to be the sponsor. And after they say that, I have a pause that's totally quiet. And I say, why? Why would you want to do that? After being a passive in 20 deals, you're probably a millionaire. Do some more passive investment. This being a sponsor isn't nothing down, no risk. It's a lifestyle, and it's something to think about. So that's just a comment on all of you. There's nothing wrong with being passive. Nothing wrong with being passive at all. I'm going to cover three things tonight in the time that I have. I'm going to talk about the 4 questions that passive should ask. I'm going to tell you what I've been working on in the last 6 months in my syndication law practice. And then I'm going to give you an idea about what we might look for in 2004 based on 2 documents that came out recently from the SEC.
And those, by the way, I just put them into the chat, everybody. So make sure that you are taking the chat with you before you leave. All right, go ahead, Gene.
I'll allude to that as we get down there. So these 4 questions, I talk about it as questions that passives should ask, but I guess if the passives are asking these questions of the sponsors, it wouldn't be a bad idea if the sponsors had a good answer. So it's a double-edged sword here. And I'm going to pretend that I'm an investor and Julianne is putting together a deal and she'd like me to invest in the deal. The first question I'm going to ask Julianne is, Julianne, I like the deal. I've got the $50,000 that's necessary to invest, but I want to ask you, if I give you my $50,000, Julianne, what happens if something happens to you?
To me, as the general partner?
To you. Okay.
Well,
that should be a conversation stopper.
That's a great question.
And there are a lot of things that can happen to Julianne, not just that she could die, and we had a number of that, unfortunately, during the COVID period, but Julianne or people that I've known in the business and represented in the business have gone bankrupt. They've been in lawsuits that are not related to real estate. They've gotten into nasty divorces. I had one client who hit his head on a rock skiing in Sun Valley and ended up a quadriplegic and in traction for 1 year. So there are a number of things that can happen to the sponsor, and the sponsor has all of the investor's money. And the operating agreement gives the sponsor the right to do things and no one else. So you can't say to me, well, the property manager will take over. And you can't say to me, well, the investors will take over. Hell, the investors didn't want to be the sponsor in the first place. They wanted to be passive. So you have to have continuity. And what that question is all about is Julianne is going to have to show me that in her company structure, her managing member structure, there is continuity. Our firm has a policy that we won't write documents, and that's what we do is we write private placement memorandums and all these documents. We won't write documents and we won't take on Julianne as a client if she doesn't have a solution for continuity. Does that make sense?
Yes. So our first question is, what happens if you die?
Well, what happens if something happens to the sponsor? The question goes toward the fact that we need to make sure there's continuity. And if you don't have continuity built in your documents and you go to the bank may very well force it on you by giving you something called a springing member. And a springing member is a corporate officer from some company that you don't even know, who, when the last member of the manager is unable to perform, springs into action and takes over all the responsibility. Well, you don't want that. You want another person, even if it's a 1% owner with signing rights, if in fact the managing member is incapacitated in any way. So that's the first question. The second question, the second question, Sean, is, hey, have you done this before, Julianne?
I have, yes.
Excellent. That's a question. I have heard panel discussions where people have sat down and said, well, I would never invest with someone who hasn't done it before. Well, I don't believe in that, because I think there are two issues when I'm talking to Julianne about this. One, I'd want to know a little bit about her real estate background. All of us who are sponsors would have had to answer that question no the very first time. So how did we get to raise any money? Well, we generally raise it from people who knew us and trusted us, and we've had some real estate acumen that we could convince them that we could do a good job. The second part of that is, you ever been a managing member of a syndication and in charge of all this stuff? Well, that's a little different. So the answer to that question really has got to be, you've got to have a pitch. You've got to tell me why I should invest with you if you haven't done it before. The best answer is, sure as hell I have. I've done it once. Okay, that's all I care about. Have you done it once? Did you start a plan? Did you get the money raised? Did you implement your plan? And are you sending out quarterly reports? That's fine. That's very fine. The third question we're going to ask Julianne is, in this investment that you want me to invest in, are you planning to have skin in the game? Are you going to invest yourself right alongside of me?
I am not this time. I don't have enough money.
Okay, that's fine. But I bet you're going to sign the loan.
I am.
Well, see, I spent many, many years thinking skin in the business was only having money. But a sponsor, after I did 16 deals, at some point in time, I was going to run out of money too. But I was always signing the mortgage. So that's skin in the game. So most of the managing members have both money and signing the mortgage. Now, I think the money question becomes somewhat of a marketing issue. How much money would I like Julianne to have in the project? She's asking me for 50 and all the other investors for 50. Does she have to have 50 in there, or would 25 satisfy me? So I think that's kind of a marketing thing. But the problem with not having any skin in the game is you're not generally taking what you're going to take out of the deal alongside of your investors, with your investors. It's going to look like you might be taking it first, or you're taking it because you didn't invest. People don't necessarily understand how much work it is to be a managing member. They think money is the most important, and I don't think money is the most important. I think the managing member is the most important. And the last thing I think I would ask Julianne is if in her agreements, I know a little bit about this, and in her operating agreement, are there any provisions for liquidity for me if something happens to me?
Oh, so, okay. And would that be if you pass away, how it would go to your beneficiary or?
Yeah. Well, what Julianne is going to say is, an article, Gene Trowbridge drafted our documents, and in our Article 11 and 12, we talk about voluntary liquidity. I want to give my shares to someone. I want to sell my shares to someone. And we talk about involuntary liquidity. I died. I went bankrupt. I'm getting a divorce, and we got to get this stuff settled or it's going to be nasty. So that answer to that question would be yes, we have liquidity provisions in our operating agreements, which I'd like you to read, and then I'll be happy to go over it with you so you know that you're satisfied. So we've got continuity. Have you done this before? Some sort of a track record, skin in the game, and liquidity for the investor. And I never once mentioned cash on cash or NOI or how many units or any of that. I don't necessarily care about that until I've vetted the sponsor and the sponsor's decisions on how they're going to set the organization structure. That's the most important thing. Because if the real estate goes right, that's great. But if the real estate goes wrong, you've got to have the sponsor step up with some experience and some knowledge and try to solve some of the problems.
Those
So,
are
questions.
those, I'm sure, Gene, there are a lot more questions. I mean, these questions that you presented here are not ones that you usually think of. The questions are, how much acquisition fee are you going to take, right? When am I going to get paid? But I really love these questions because not a lot of people think about, they're a little bit off that what we usually see.
Well, Julianne, I don't really care what the acquisition fee is. If you're going to be an individual managing member, I wouldn't invest with you if you had no acquisition fee.
Say that one more time.
If
you would not invest with me.
I would not with you if you're going to be the individual managing member. I could care about the property because something happens to you and life goes on, right?
That is great.
Most projects are going to last 5 to 7 years on an average in real estate. And in 5 or 7 years, there's a possibility that something is going to happen to either the manager or the member. And in my 4 questions, we have some discussion of how we might handle that.
Amazing.
Sure. In the underwriting process and all that all you passives have learned about how to vet a deal, we have all those other questions. But why go through all that and find out that you don't have a sponsor you want to work with?
Yeah, fantastic. Anybody have a question that is coming up for you of what Gene has shared? Let's open it up. I think Paula had one. Are there any provisions in the company agreement that support the passive investors? Does that company agreement contain rules for engagement for subsequent partners? Does each sponsor have a personal relationship will in place that addresses ongoing concerns?
Well, those are a lot of questions.
So my question, Gene, is if you have 2 managing members and one passes away, then you have the other one that should be able to freely operate the operation and close that deal. By that, I mean, do whatever they needed to do in their business plan toward the sale of property or just to keep it for a return on investment. So what I think I'm hearing you say is that not only for the company agreement that addresses the syndication, there needs to be that provision in that company agreement. But also if a partner passes away and there's an estate that has to be addressed for, say, the will, each person should have a will because the siblings, you don't want it to end up in probate and then have your property sequestered in any way that prevents the investors from getting a return back on that investment. Is that correct? Because we ran up against that in one of our agreements as well.
Sure, that would be a good idea. I don't actually think that my agreement requires the managing member to have a will, but that would be a good thing. I do know that if the first lead managing member goes and the second person takes over, there's always a provision in the operating agreement that the members can vote in someone else. So we shouldn't go ahead with just that secondary person. We may have to go and vote someone else. And when I was a syndicator in my 16 deals, I had a S corporation that was the managing member in those days, the general partner. And that S corporation had a board of directors, okay? 2 shareholders, my wife and I, but a board of directors and a life insurance policy that would allow them to hire someone to do the work if something happened to me.
Who decides that person? Who decides that?
The board of directors. The board of
directors does? Okay.
So, but that was a little different because there was an attorney, a CPA, and a property manager that were on my board, so they would make a good decision. But you're bringing up all sorts of stuff that tells me I've got the right first question. If there isn't any continuity, what are all the things that we could face into? And let's not do that. And I will tell you one situation we ran into where if I'm the managing member put their spouse
Yes.
in as a 1% owner, the managing member died and the spouse had no knowledge, no interest, no ability to run anything. And so we had to call on the operating agreement to allow us to vote in an additional managing member with the authority and the skill set to run the project. Because more than likely the project isn't ready to be sold right then, Paula. You still have to take the project, forward.
And then that 1% person may not have desire nor ability to make those types of decisions.
Right. And I guess if I'm going to invest, if I'm asking Julianne, what's your continuity plan? And she says, well, I'm going to put Paul in for 1%. So my question is, okay, what the hell does Paul know about all this? And so that becomes a marketing issue. Not technically that works because there is continuity, but is it a marketing issue? And am I satisfied? Sean, what do you think about that question?
Well, Gene, I'm definitely adding that to my list.
I am too.
I think,
Gotcha.
Continuity in any business has always been an issue. I worked at Southwest Airlines for 14 years, and they were huge on having continuity. When Herb Kelleher was still the CEO, they already had Gary Kelly lined up and marching to becoming that next person, and then they had one or two other people behind him just in case. And they do that for all their key positions. We as small business owners, and that's what we are. We're small business owners. You may be not small in terms of monetary sometimes, but it's definitely small in terms of number of people. That continuity is critical.
Yeah, I think so. And
So,
liquidity for the investor is important. We have a situation going on right now that the managing member called me, and one of the investors is in the hospital expecting to pass on and needs to sell. Well, what does the operating agreement say about that? What is the steps? Most operating agreements say that that person could set a price and it should be offered to the members, and then it should be offered to the manager, and then maybe the company can buy it, or you can go on the open market. But there has to be a strategy there. And then the question is, whoever buys it, do they get to vote? You can't eliminate the person's ability to sell their economic interest, but you sure as hell can limit the person who gets the shares, the ability to vote. We did have a person who died and who left his partnership interest in part of an estate, and someone went to his chauffeur. Some of it went to his barber of long standing. And I don't know what the third lady was, but someone went to the third lady, and we're pretty darn sure that none of them should be voting on the company decision.
So Gene, I have a question. So we've gotten through a lot of bridge lending issues, and we're going to continue to see those this year. We've got a lot of passive investors who put their money in, not knowing. We were all running to the next deal. We put our money into this bridge loan, and now the value of the asset is not worth what it was when they bought it. What can the limited partner, if anything, do to protect their money? Does the general partner just get to walk away and say, sorry, we lost? Can they say, hey, I want to buy my shares when it's not worth anything? How does that discussion go with limited partners? You really can't go in and out of these deals, right? So kind of walk us through that from a legal standpoint. What do these passive investors have on the line, and what any recourse that they can have in getting their money back?
Well, everything goes to the property in that case. Everything counts on the property. If you put $5 million down, okay, bought a $15 million property with a $10 million loan, and now the property is worth 10, there is nothing you can do. It's not the managing member's fault. There's nothing you can do. I was syndicating in 1994, which is before many of you, and that time was just as bad as 2008, and there was absolutely nothing you could do. Even a capital call wouldn't help because the value was gone. So there's nothing you can do, and you can't blame the managing member. Now, I think there are times where the managing member kind of screws up, and then you can blame the managing member. But what are you going to get from the managing member?
So I have another question on that, Gene. There are a lot of debt funds out there that are putting some maybe of these deals at risk. They are not giving back their draws in a timely manner. They're not, they're holding off on a lot of things that they were supposed to do. I know the person that has the money makes the decisions and so forth, has the power. But is there anything that a general partner can do to protect themselves against a lender that's not performing to what the agreement was? What are the options there?
Can the members take action against the lender who isn't performing according to the loan documents? No, the managing member can take action. And I guess the members have the right in every document that we write to send a letter of notice to the managing member that they need to take action. And the managing member has 30 days to correct that. And if the managing member doesn't, then the members within 30 days can vote the managing member out, put someone else in there who will take action. So, everyone uses the term limited partners and general partners. I'm going to be kind of a bad guy here. We haven't had general and limited partners for years. That's limited partnership language. We have members and we have managers. And the members really are still limited in what their authority is and what they can do. The good thing about the manager is now the manager has limited liability, where general partners didn't have limited liability. So, the members have to be aggressive. The next thing I'm going to talk about when we get there is what I've been working on for the last 6 months, which is exactly what, who sent this chat talking about bridge loans and interest rates and everything. Maybe, I don't know if Adrienne.
Yeah, let's go
right
to the next one. Yeah.
It's what I've been working on for the last 6 months because this is an overstatement. Let's put it this way. Deal flow has slowed down.
Yes.
All of my peers would say that we're probably at about 50% of deals in 2023 that we did in 2022. But that doesn't mean we're not busy. We're busy dealing with capital calls.
Yeah.
And most of the capital calls are because of the interest rates. You get a bridge loan. The bridge loan people want you to put X number of dollars in the bank as a reserve for rising interest rates. But when interest rates were 3, reserve was to cover them if they went to 4.5, but not if they went to 7. And all of a sudden they're at 7. And or the bridge loan that was made 5 years ago is now coming up in a period of time where the $15 million property is only worth 10. And it's going to be, you're going to have to refinance or do something. So I've been working on that constantly. And I will tell you, I want to limit this to capital calls. In my opinion, good capital call provisions in documents start with the ability that the managing member has the right to go out and look for third-party money. That's their number one choice because third-party money is in the hands of people who make loans. So that's probably the best place to get money if it's available. Then the next thing the operating agreement says is that the manager can make an advance. And if the manager makes an advance, that would be great. I did that many times when I was a syndicator. And the provisions in the cash distribution language are that manager advances get paid back first before any cash distribution happens. Because the manager's not in the business of funding the deal. If they can, that's great. And then it looks like a loan. It's not a loan. It's just an advance. And then they get paid back first. That makes sense. Third, we go to members. Are there any members out there who can make loans? And the member loans are attached to a priority payback. Member loans get paid back before there's any other cash distribution. That's good. And then the last and the least effective is a flat out capital call. I don't believe in writing documents that give the manager the unilateral right to make a capital call with provisions of dilution if you don't make a capital advance. Now, some of my clients insist on that, and so I'll write the document, but I don't really think that's true. I think in a capital call, what you need to do is you need to tell the investors why there's a problem, how much money is necessary to solve the problem, and if we get the money, this is what we're going to do with it, and we're going to solve the problem. And then the people vote.
Let me just make sure that we understand that there's a lot of new people here. So capital call is when you need to bring in some extra money after you've been in it for a little while. And we need some operating capital. So you go out to the investors and ask them, hey, can you give us 50, 100,000? If you choose not to, and what Gene is saying is that you write this into the contract where typically now, if you don't contribute money to that capital call, your shares get diluted. It's not worth as much. But Joe, who has a little extra money, is going to give money to the transaction. He will hold on to his shares and take on more for that. Would he take on more, or he just keeps the amount of shares that he has, right?
You just recalculate the percentage interests.
Uh-huh.
The people who have put more in have a higher percentage interest, and the people who didn't put anything, their percentage interest would drop, and that's what they call dilution. I mean, of all the people that I've just talked about, third-party lenders, the manager, and some members who can make loans, the least possible group of people who is going to give you another $50,000 a piece are investors. Because they're invested all across the board. They're leery. I've heard this comment, well, why would I throw good money after bad money? Well, it's not bad money. If we can wait this out, it'll probably be fine. But if you can't, you can't.
So Gene, let me ask you a question. So you're saying for the operating agreement up front that this is how it should be
You should
written.
read that. You should read what it says. I have clients. There's no question I have, and I don't agree, but they're my client, who says that the manager has the absolute right to make a capital call, and the people have to invest within 15 days. And if they don't, they're going to be diluted. Well,
so in this case, what Gene is saying then is if you're going to be a passive and you're looking to for questions, this is another question. What happens if there's a capital call? And really make sure you understand what it is, what your obligation is if there's a capital call. And on the other side, Gene is saying as a general partner, this is something that you should write into your operating agreement as something very necessary to make sure that you keep your investors whole, right?
Well, if you don't have a capital call provision, what happens if you run into a period where you need money? I mean, you can always amend the operating agreement to add a capital call provision. The ones I like the best is a relatively simple capital call provision that says the manager can't do it unilaterally, but on approval of 75% of the members, this is the plan. And then the next section says if they don't like that plan, the manager can suggest a different plan until we get 75% approval. But that doesn't mean they're going to put the money in. That only means, sure, I approve, but someone else puts the money in. And so one of the strategies we've come up with this year is we've We've made a capital call, and we've determined which members are willing to put money in, but we haven't effected the capital call. We've then gone back to step 3 and gone to those members and say, you know, we're allowed to accept member loans from you.
Mhm.
And there's going to be an interest rate stated, and there's going to be priority repayment plan. Maybe you guys can come up with the money that we need by making loans to the partnership, the LLC. And that has really worked. That's been a good plan. The last thing that I haven't mentioned, it was just tough. There's a provision in most operating agreements that if all the capital call provisions fail, you can open up the sale of interests to existing and new members and give them priority returns and returns greater than the original investors. Because you have to have some incentive for someone to buy more or to come in later. So that's what we've been working on. And whoever sent me that message about interest rates on bridge loans is right on target. That's the biggest problem. The other problem with capital calls that we're having now is the people who are in the 5th year of their bridge loan and the property values have gone down and they simply have to refinance. And that may take some extra capital to buy down the mortgage. And so that's that's more than I want to talk about now.
Yeah. I mean, all this is incredibly important for both general partners and limited partners. That whole piece right there, really important.
I love Paula's comment. She said, I was told once that if we did not give money, we would completely lose our original investment. This is what Robert Kiyosaki calls swimming naked. And, you know, I have seen capital call provisions like that. And those are draconian. That doesn't work. And first of all, I know people who will never invest in a deal with a draconian capital call. That's one of the first things that they look at. Maybe I should make that question number 5.
I think so.
Investors ask, what are your capital call provisions?
Yeah,
So
I love it.
And that's really deep. I know we're running out of time, but I just want to cover a few things.
All right. So I want to.
Okay.
I'm sorry, Gene, I want to know, there's a lot of hubbub about what's going on with the SEC changing the accredited investors. I have put 2 documents in the chat for everybody to review. This is something you need to understand both as a limited partner and as a general partner. Make sure that the relationships that you're building are with people that can get into your deals and how you have these relationships. So Gene, give us some of your thoughts on that.
Okay. The 2 documents, thank you, Julianne. The 2 documents that she put in there, the first one is called, it's called the OASB report. And what does that stand for? The Office of Advocate for Small Business Capital Formation of the SEC. So here's an organization that is all designed to help capital formation. Here's something, and I just have 5 bullet points. Number 1, according to this report, and it just came out in December, 99% of all businesses in the country are small businesses defined as being under 500 employees. 99% of the businesses. 90% of the capital that's formed, capital formation in the country, goes to small businesses. They do not get their money from Wall Street. They get their money from private placements, which is what we're talking about. Regulation D, crowdfunding, Regulation A, the type of offerings where you don't have to get a registration statement from the SEC to raise money. And let's talk about how big that is. In the 12 months that this report studied, $2.7 trillion was raised in 506B offerings. 35 sophisticated investors, unlimited accredited investors, no advertising. 2.7 trillion. There was only 1.1 trillion raised on Wall Street during the same period of time.
Wow.
Now, people say, well, that's fine, but what about 506C? Boy, you can advertise. In 506C, it was 169 billion compared to 2.7 trillion. So it's just nothing. Regulation A, 1.5 billion, nothing. 506B is the deal, and I'm harping on that right now. 506B is the deal. Remember this, 35 sophisticated and unlimited accredited.
So before you go on, Gene, tell everybody what does sophisticated mean?
Oh, 3 words. Okay. Sophisticated. Sophisticated means that the people can read the documents and through their education or their experience, understand what they're getting into.
Okay.
That's good enough, right? The summary of that report, it's so very interesting. They have a whole section on how it's more difficult for women to raise money in the private placement market, how different ethnic groups have trouble raising money. It's almost a 100-page report. It comes out every year. I get it as soon as it comes out. It's fascinating. And their punchline is, you can't do anything to the accredited investor rule that is going to minimize the ability for small businesses and their ability for capital formation. You just can't do it because we need more capital. Okay. So a week later, here comes the other part of the SEC coming out, and that document is called the Review of the Definition of Accredited Investor. In Dodd-Frank said that the SEC every 4 years or more should do a review of accredited investor and see what it had to do. And historically, accredited investor definition from 1981 when it started until now has always been expanding and expanding. So there's more and more accredited investors. That's good for capital formation. And they say that's why they're doing it. Except for Dodd-Frank, which took your home ownership equity out of the fortune. And that took 1/3 of the accredited investor household in the United States away from being accredited. Okay. That took it down to about 16% of the households in the United States are accredited. It went from 24 to 16 by eliminating home ownership, which is probably a good thing. They're probably to protect investors not to lose the equity in their home in case they made a bad decision. And accredited investors, by definition, don't need protection of the government. But the government at that point of time, right after the crash in 2008, thought that maybe all investors needed protection from their home equity. So that's the change they made. But other than that, everything has grown. Now, in 1981, when this law came out, Reg D, I was in the middle of syndicating, and they gave us a definition of accredited investor. $1 million net worth, $200,000 in a family. That was when $1 million was a lot of money, right?
Mm-hmm.
It's never been adjusted. It's the one adjustment they had is they made $200,000 just be for a single taxpayer, and they added $350 for a household. Well, that was an improvement in the ability for capital formation to give us more accredited investors. Today, the government thinks in this report, 18.5% of the households are accredited. Okay. One of the proposals that they're looking at, and they've been looking at it every year, and I hear all my other patrons, all my other peers say, oh, it's going to happen, and I don't make any predictions. It hasn't happened yet, is that they would adjust the dollars for inflation.
Mm-hmm.
Since 1981. And that would take the 1 million to 3 million. it would take the 200,000 for an individual up to 600,000. And it would take the 300,000 for a family, or 300 for a family, to 900,000. So everything is kind of tripled. That would reduce the number of households that are accredited to 6.5%, from 18 to 6.5. And then in their horror story, they say if there's never an adjustment to inflation, they expect by 2032, 30% of the households will be accredited. So they're proposing we talk about two things. There's no proposals out there. This is just a report that's open for comment. They're proposing two things there. Number one, we start today and apply inflation going forward. We apply all the inflation at one time and start today with new numbers. Or, and I could get very political on this, I'm not going to get political on this, they want to do with your retirement funds the same thing that they did with your home equity. Take your retirement funds out of your calculation of the $1 million so that your retirement funds are not at risk. Okay? And that goes back to a provision in one of the previous presidents' time in office where all retirement funds should be invested with the United States government. We would lose self-directed IRAs. We would lose all that. That didn't go anywhere there. But so here's what we have to look at in 2004. We have to look at a proposal coming from the SEC, open for comment with what they think they'd like to do. And in the past, they've done these proposals. They come out, they give the public 90 or 180 days to comment. They take it back in-house, they think about it, and they come out with their final rules and regulations. So it all takes about a year. So the things that I think they would come out with are total inflation adjustment, starting now inflation adjustment, and or some combination of your retirement funds. However, the last whole section of the SEC definition of accredited investor document talks about what the Office of Advocate for Small Business and Capital Formation says. You can't mess with the accredited definition, because if you mess with the accredited definition, we're not going to be able to raise the money that people need. Think about this. Think about a deal where you have 35 sophisticated investors and 50 accredited investors. If the definition of accredited investors is such that half of those people are no longer accredited, you can't raise money from them, but you're already full at 35.
Deals are going to be hard to get done.
It's going to be harder to raise funds. Now, maybe there's a solution that 35 should be changed to 50.
So let me ask you a question, Gene. We got to wrap up here. Can we, as investors, be part of that proposal to add comments?
What I would do is I would go to the link that you put in there for the SEC,
Okay.
and have people read it. And there's instructions on how you can send comments. One of the things that I've seen in the past on this, and I'll end up with this. Real estate is not the biggest game in this. Real estate maybe is 20% of that 2.7 trillion. Even my little office does a lot of businesses. We helped someone buy a hockey team this year, a professional hockey team, fiber optics, all sorts of things that aren't real estate. There's a lot of, every business eventually needs capital, not just real estate. And the $2.7 trillion is raised primarily by the broker dealers. The broker dealers have clientele. They don't need to advertise. if you told the broker dealers that their accredited investor list would be cut in half or from 18 to 6%, they're going to scream like bloody murder.
Yeah.
And they're a big part of this. They're a much bigger part than we real estate syndicators are. So there'll be some pull and tug with that. So that's good. Thanks, Julianne.
Listen, I want to tell you, you are so passionate about this. You know, we don't want you to retire. We don't want you to stop doing what you love, because you're kind of like peanut butter. We just want to spread you around, and you have such a good knowledge of this information. Thank you for being so generous with your
You know what
time.
my hashtag is?
I don't.
Not retiring.
Not retiring.
And on my 36 half marathon bibs that they give me, they want to know what I'm called. I put down not retiring. There you go.
Well, thank you so much for all that you do for this industry. So many people, if they wanted to get a hold of you, Gene, to write up an OA or to ask some questions about the capital call that was just pronounced on their deal, how would they get a hold of you? What is the best way?
Well, the best way would be, my email is Gene, and it's in chat. It's Gene at TN LLP, Trowbridge Nieh LLP, TNLLP.com, or my direct number, and I answer all my own phone calls, 949-855-8399. There are 6 of us in the company. We all work virtually, and Jonathan and I handle our own clients, and no one's ever passed around to anyone else. So we'll handle your call.